Cambridge University, where she got her degree. Madhavi's practice spans over a wide range of issues: constitutional, gender rights, free speech, environment, and commercial law. She appeared for the Government of India in some landmark cases, including the Triple Talaq case, the National Judicial Appointments case, criminal defamation, amongst many others. She is also the author of media law book called Facets of Media, law used by lawyers, students, and media persons. She writes regularly on free speech related and gender issues. Now I call upon Ms. Madhavi Diwan to please take the stage. Thank you.
Namaskar and good afternoon. I think it's very hard to be inflicted with yet another speech, particularly after a very sumptuous lunch. So I'm going to try hard to keep your attention. Thank you, first of all, to the organizers for inviting me to this summit and to this lovely city, which has grown and expanded by leaps and bounds since I last saw it. But it's a lovely city, your Hyderabad. It takes in the best of many worlds. I'd say, the majesty of the past and very much modern city as well. And I think this has some relevance for the issue of on gender rights and women, because we really need to combine the best of both worlds, both the traditional and the modern. I think that is the only recipe for success. I think when we look back at the journey of women in India over the last 70 years, I think it's a story of very curious contradictions. On the one hand, we have fabulous stories of women making such enormous strides. You have them asserting themselves in so many spaces which were completely the monopoly of men till not so long ago. So whether you have the badminton court or the boxing ring or the boardroom, they are the helm of banks. So you have women asserting themselves in those spaces so confidently, so spiritedly, and I think that is a matter of great pride. But I think we also know that beneath the sheen of those very shining examples, the ugly reality is that our women are often not safe on the streets. They're not safe in the workplace. They're sometimes not even safe at home. And also, sometimes they are not safe in the womb of their mothers. So this is the ugly reality. This is the paradox. And, how do we deal with it? The underlying truth is that when a society cripples the progress of women, it's really doing a great disservice not just to women but to itself. Because ultimately, when our politicians sometimes talk of, say, reservation for women or some benefits to women, it's almost like they are, just throwing some crumbs at women. It's a section of society, just, keep them happy. But I think what we, in that very myopic and blinkered approach, what we tend to forget is that women is the biggest constituency, the biggest minority in India, in the sense that it's half our population. It transcends the barriers of race, of region, of caste, of religion, all of those, because half of every community is women. And if we neglect that, we are doing ourselves a great disservice, because we are not adequately tapping that phenomenal potential and talent that women are and that women can bring to the table, because they can contribute so fabulously to society, to the economy, and they can nourish families. And they do need a little hand-holding for that. And the family is ultimately the most basic foundation of society. It's going to dictate to us how our society, how our nation, how our civilization is going to go from here. So therefore, it's a very myopic approach to think when we talk of benefits for women, it's women alone. No. Without women, effectively, we are running a one-legged race. It's like an aircraft flying on one wing. We're just not on full steam. So I think that's something that we need to bear in mind. And as far as our constitution and legislation, which is what I am supposed to be speaking about, I'd say that the beauty of our constitution is its phenomenal dynamism and elasticity. So you have there a very a strong foundation, a very strong edifice of basic values, of fundamental rights, of constitutional morality in the Constitution. That is something which is completely unimpeachable. But at the same time, you have phenomenal elasticity, dynamism. It's able to reach out in different ways to meet the challenges of the times. And that is the great beauty of our Constitution. So we've had the courts, and particularly the Supreme Court and the High Courts in some measure, they have reached out, creatively interpreting our fundamental rights, our rights to, whether it's equality or the right to life, the right to dignity, under Articles 14, 15, 19, 21. So through a very creative interpretation of these fundamental rights, the courts have really pushed the envelope. They have really expanded the frontiers, we will see, on gender rights and gender justice. And we will see that through the various stages of a woman's life, right from her birth or even before her birth, right, to much later in life. They have dealt with so many, and they are dealing in real time with so many of those challenges. And it's a fascinating place to be sometimes, the Supreme Court of India. So the courts have done this sometimes by striking down legislations or provisions in legislations which are very arbitrary or discriminatory. Or you have the courts sometimes filling in a vacuum where there is no legislation at all. I'll give you examples of those also. And then sometimes they direct the government that, I think you need to legislate on this. So please come up with something. So it's egging on the government to do something, the legislature to do something. And then you have certain statutes which are there on the statute book, but they're just, gathering dust. So the courts have pushed government, the executive, to implement statutes. So that has been the relationship between the Constitution, the courts, and legislation. Now, the challenges in a woman's life really begin very, very early. They begin before she's born, perhaps even before she's conceived. So it's a challenge sometimes even, getting into the mother's womb because, we have sex selection techniques which eliminate the possibility of a female fetus altogether. So, the scourge of sex selection, this obsession with the male child is something that, the courts have tried. Of course, eventually the courts can't do everything. What will have to change is our mindsets, and to begin with our mindsets as women. And I will give you one horrific example, which, at some stage that story reached the Supreme Court as well. That there was a case in the Beed district of Maharashtra, some of you may have heard of it, where a doctor couple, a husband and wife, were running a clinic where, this was a sort of almost industrial level female fetus removal. And they had engaged, this is horrific, they engaged hounds to eliminate, to consume those discarded female fetuses. So this is the cruel paradox in our country, that our women are not even safe in the hands of women. That you can have a doctor actually do this to a female fetus and leave them to be consumed by hounds is something that is really puzzling. So you had in a series of cases, the courts, the Supreme Court of India actually egging on government for implementation of the PCNDT Act of 1994 because not much had happened on implementation. So it was monitoring. And you know, sometimes all of us do question, why is it that the courts have to micromanage? And some of those orders and judgments, there's no great constitutional jurisprudence in them. What they're doing is really egging on the government that you must implement. How soon are you going to do it? So they are sometimes very routine administrative orders, and you wonder why the courts should be doing this. But at the end of the day, we must acknowledge that the courts have done a great deal to really get the act to be implemented, and a lot of those doctors running those sex selection shops, if I may call them, had to shut shop. In the process, of course, there are some genuine doctors who have, you know, faced some harassment, but still, I think the net effect has been somewhat salutary. Then you have, for example, the Sabu Matthew case, where the court went to the extent of, you know, instructing internet intermediaries to auto-block sex selection websites. Now, a lot of critics have argued that, you know, why should the court be interfering with internet intermediaries? This is technologically, it is wrong. It has a chilling effect on free speech. And yes, it is arguable. But at the end of the day, I think it shows a certain earnestness on the part of the courts to try and ensure that, you know, there is some consciousness which is generated, and you know, that the system, that as a system we mean business when we want to eradicate this awful practice of sex selection. I'll move on. Once a girl child, you know, has the privilege of getting conceived and coming into the world, the next challenge is, of course, you know, what is she going to eat? What is the level of her nutrition? Is she going to go to school? How far? Which school is she going to go to? You know, is there going to be access to a toilet? That's a very important question. And believe it or not, the Supreme Court has concerned itself with all these questions under the larger umbrella of Article 21 of the Constitution. Now, for example, again, you will ask that why should the courts be concerning themselves with, you know, the nitty-gritties of the construction of toilets for little girls? Why should they be bothered? Can't they do something else with their time? It's precious time. But I think it is a recognition of the fact that, look, if there is no access to a toilet, the girl child will probably not be able to go to school. You know, issues such as menstrual hygiene, all of this is very, very, very important to be able to ensure that a girl goes to school. Moving on from here, when a girl child, she turns adolescent, there are other, you know, fears, other concerns, stalking. You find, you know, the horrific cases of acid attacks, more, you know, serious sexual crimes against women. And we find that here too the courts have intervened, sometimes passed very, you know, far-reaching judgments, Nirbhaya's case, so on and so forth. But I think what's important here is that it's not just about the cases of these individual victims of crime. Of course, you know, they are horrific crimes and they must be condemned, and, you know, there should be zero tolerance for that kind of thing. But the ripple effect of one horrible incident like that can throw the lives of so many girls out of gear, because it means once, you know, parents and families are concerned about, you know, safety, physical safety, it translates into lost opportunities in so many fields. Whether she's going to be sent to, you know, if she has to walk in the rural areas a long distance to school, is she going to be sent to school? Is she going to be sent to college? Is she going to be, you know, if she has prospects in getting into a college in a different city, will her parents worry themselves sick over her safety, or will they send her there? And therefore, will she be able to work in a workplace where she has to function into late hours of the night? So all these opportunities, all these prospects get impacted. So physical safety is not just about actual safety, it is about lost opportunities also for women. And there too we find that the Supreme Court has taken, you know, several measures, again implementing statutes, sometimes striking down discriminatory provisions, and really, again, as I said, pushing the envelope on gender rights. Now, you have, for example, interesting cases on career choices, because that's the next stage. Once a woman is, a young woman is reasonably well educated, she wants to enter the work arena. Now, career choices. For example, there was this case of Anuj Garg versus the Union of India, where the court struck down a provision in a Punjab statute which actually prohibited women from working as bartenders. And they said that, look, in the garb of protecting women from, unsafe conditions, you cannot impose choices on them. So this kind of a majoritarian morality, what they called, these patriarchal standards cannot dictate choices for women. And that's an important judgment. You will find again, there was the case of Charu Khurana. She wanted to be a makeup artist in Bollywood. And again, for some reason, they did not allow women. So there too, the court pushed the envelope. And then you have the very interesting case of the bar dancers from Maharashtra, where the Supreme Court upheld the judgment of the Bombay High Court, where they struck down the prohibition on bar dancing. And I think the state felt that, look, public morals and public morality will be seriously offended if you have, women sensuously gyrating to music in a bar. And the court said that is, it's not for the state to be imposing these moral standards on young women. And because there was a discrimination there because in five-star hotels, there was no prohibition on bar dancing. And they said that, look, you can't impose one set of morals on poorer people who do not have access to five-star hotels, and a different set of moral standards for people who are lower middle class and so on. So the court actually struck down that prohibition. But the state of Maharashtra has actually come up with a new law where they want to again prohibit it, because what they say, and they say something very interesting here, they say that, look, there is another constituency of women, and that those are women who are the wives of men who frequent bars, and they feel that the family income is being squandered uselessly on bars. Men are spending, long hours after work in these bars. They're not spending enough time with their families and children, and this should be somehow prohibited. So that's also an interesting argument, and let's see how it all turns out, because the second round is also under challenge in the Supreme Court. So that's an interesting balance, the right of some women to, practice the profession of their choice, and on the other hand, there are other women who feel very strongly about, they want their husbands home for their families. And then, of course, you have safety of women in the workplace, sexual harassment. There you have the Vishakha guidelines, which was a landmark judgment of the Supreme Court way back in 1997. There was over there a complete vacuum in the law. There was no law at the time on sexual harassment, and so the court filled in that gap by putting in these guidelines, and it took 13 long years for Parliament to come up with a statute. And even this statute is, we are seeing, companies, workplaces, they're setting up this mechanism. It's still, in a sense, in a nascent stage. But there are challenges there, because I think it's very difficult even today for women to, genuine complainants to come forward and share their stories, because there is a stigma which is attached to it. Women are branded sometimes as troublemakers. They become unemployable sometimes because they have complained. So should they or should they not? And oftentimes they feel it's just practical good sense not to do that. And that's very, very unfortunate. At the same time, we do know that laws like this are misused. And it's very important as women that we ensure that these laws are not misused, so that because it loses credibility then. And what happens in the process, that genuine victims are not able to come to the fore, or they are not taken seriously. So that's very important to safeguard against abuse of such laws. You have other laws which are really intended, again, to keep women, to sustain them in the workplace. You have a new law on maternity benefits, which gives you 26 weeks of leave after the birth of a child. Now, this is a very, very welcome move at a certain level, because, you know, a woman is less stressed, then she doesn't have to rush back to work. The child is not neglected. But at the same time, I think it's also important to think about whether a woman will be rendered unemployable, in the sense that it becomes a disincentive for the employer, because there's no requirement that he has to engage a woman. So he might choose a man over a woman. So we do not also want women to become unemployable, or, you know, that they drop out of the workforce because of such challenges. And you know what also happens in such cases, that at least we find, and I find this very much, you know, in our legal profession, that because it's a profession and not a job, and I mean personally also I faced this at some level when my children were very, very young. I tried to come back to work as soon as I could within, you know, 2 or 3 months, but I had no work to come back to because I was a professional. So it wasn't a job. So I had just had to wait over there till the next brief came along. And believe me, it was very, very trying, as I'm sure many, many women over here have also experienced those challenges. But what tends to happen in the process, even in the case of a job, is that even when the woman comes back, she may get all that leave, she may get paid leave, extended leave, all those benefits, but in the process, she's left out of the cutting edge work. And gradually she sort of falls off the map. Now that is also something to think about and see how we can really ensure that women stay there in the workplace. They get the, you know, the cream of the work. And I was actually fascinated to meet in the audience at least 2 people who seem to employ women who are, you know, women who can work from home. And I think that's a fabulous resource. And it's not just helping women, it's helping them. And, you know, work is happening on the terms of both the women employees and their employers. So that's a, you know, a fabulous resource. We have to get more unconventional methods into the system. A very little else that I will say. One major point that I do want to touch upon is, you know, in areas of religious reform, we've had, you know, the courts interpret Article 25 of the Constitution, which is the right to practice religion. And there are so many practices, triple talaq being the most recent one, which was tested in the Supreme Court. But we generally find that the courts are reluctant to interfere when it is a case of uncodified personal law. Very, very reluctant. But we've still had some landmark judgments. Triple talaq is one. The Haji Ali case, entry, access into places of worship. Sabarimala is pending. So there are all of these cases. Then you have, for example, what is again pending right now is the Parsi case, where 2 women, 2 sisters who were born as Parsi Zoroastrians and who married non-Parsis, they were not allowed to enter the Parsi places of worship. And therefore, does one lose the right to religion, to practice one's religion only because one marries outside the community? So these are very, very important questions. There will be another case which will come up sooner or later. It's already filed, challenging the practice of female circumcision in the Bohri community, the Daudi Bohri community. So this is a range of issues, very burning issues. But as I said, what we find is that the courts are generally, they tread very carefully in matters of religion, as they should. But what seems to, you know, and we faced this in the triple talaq case also, we thought it would be a cakewalk, but it was a 3-2 majority. And what seemed to, you know, the judicial reluctance was because they kept saying that, no, but there's no law yet. And if there's a law, we can test it. But simply in the area of personal law, we do not want to interfere. So on the one hand, you have judicial reluctance, and on the other hand, as we've seen in India on issues like triple talaq, you have had legislative reluctance for the last 70 years. Now, of course, that status quo is changing, and most likely we will have a law very, very soon. But this combination of the legislature hasn't done, so the courts will not do, and the courts haven't done, so the legislature will not do. So this is a very difficult, and what happens to the victims of all those practices? So this is something to think about. And so I think I have given you a broad brush of constitution and certain legislations and laws and personal law, etc. And of course, I'll be happy to take any questions that you have. Thank you very much. Would you like me to remain here? Are there any questions? Yeah. Yes, the lady here.
Madam, I have 2-3 questions which are unrelated questions, 2-3. One is, as you said, the bar dancing by ladies. It is their freedom of expression. And then again, those bar dancing ladies, if some molestation or somebody touches badly, that again comes into a big problem. Again, they'll say that this thing is violated. There is another thing, you said about women getting leave 28 weeks maternity. Actually, the organized sector and government women are very less. The unorganized, the type of laborers, labor women who work, they don't get at all. This is the kind of India we have. And the last one is, when our constitution is secular, why should personal laws should be there?
Why should personal laws?
Personal laws are still continued. It
Yes.
is a British legacy. Why should it be continued? Why shouldn't we get uniform civil code?
All right, I'll try and answer that. To start with your question on bar dancers, look, whatever the profession, whatever the choice, unless it violates the laws on decency, and so far it has not been found to violate the law on decency. It was struck down by the Supreme Court on the ground that it is unfair to discriminate between different classes of hotels and bars. Now, if a law does not violate decency, whether a woman is a dancer or a singer or an actress or a lawyer, she is entitled to a certain, a dignity of labor and of her profession. So, look, women are sometimes harassed even in the most quote-unquote decent of professions. And even a woman of loose character, nobody has the right to molest or sexually harass even a woman who is a sex worker. So, therefore, if a lawyer or a woman in a corporate job also is sexually harassed sometimes. So therefore, to say that, because a woman is a bar dancer and therefore she will complain because she is harassed and then there will be further problems is not an answer. Is not an answer. Because you're seeing even in America today, this whole Me Too debate, you're seeing the number of women who are coming out and speaking about sexual harassment. So this is a huge global problem. And, at a certain level, we are in a state of churning. Sometimes, see, 70 years ago, where were our grandmothers in the workforce? Right? So society is changing. Even in our generation, perhaps our menfolk have not, or men of our generation, have not seen their mothers working. So sometimes, even though they are trying to adjust to that new reality, they find it difficult. So, therefore, these misogynistic or patriarchal attitudes come into play. And therefore, I think it will take a little time, but we've got to chip, little by little by little, and ensure that every woman, if she chooses to be a dancer, singer, actress, whatever, so long as she is not violating any law, I think she has the right to practice. That's number one. The second question, just remind me, was on equal pay for equal work. I completely agree with you there that every woman should be entitled to the same pay. In fact, our constitution, that is a fundamental right under the constitution. We just need to fight harder for it. The third on why personal laws continue to exist in our country. You see, I think the beauty of our system in many, many, many ways is the fact that we have a very plural and diverse society. And I think that plurality and diversity must be allowed to flourish. However, the Lakshman Rekha in my own view is, and this is what we tried to contend in the triple talaq case, the Lakshman Rekha is fundamental rights. So whatever your religion, whatever your practice, whatever it is perfectly acceptable till it violates fundamental rights. And you see, in the triple talaq case, some of All India Muslim Personal Board, etc., their argument was that no, this is personal law is like an impregnable fortress. Unless it becomes a legislation, no court can test it. That was their argument. Now, that is a completely flawed argument because I would say that since we have, as Indian citizens, we have all bound ourselves under one constitution. We are ultimately answerable to that constitution, and that constitution provides equality for men and women. It provides a right to dignity for women. So that is the line we draw and say where fundamental rights are violated. You cannot say that fundamental rights cannot be asserted qua a particular religious practice. So all of these practices, I would say, the courts have not yet ruled on this aspect, if it's not a law whether to. But then you will have practices like female circumcision, otherwise triple talaq at a certain level. So many other practices. Would not even sati maybe. They would have said that no, it's part of personal law. We will not allow anybody to touch it. That is not acceptable. It has to conform to fundamental rights. I think that is that. And you see, uniform civil code, when we talk about, it's a long journey. And I don't think that by uniform civil code we want to homogenize everything or every law, because that, will take some color away out of society. So we must have our diversity, but we must have reform so that we come up to speed with the constitution. That is essential. So, just as we've had Hindu reform under the Hindu Code Bill, we must have eventually a Muslim Code Bill, and similarly other communities who have been left behind. So that's my answer to that. Thank you. I'm sorry, I can't hear you. You'll have to take a mic.
Advocate, what are your thoughts about surrogacy?
That's a very interesting question. That is a very interesting question, and I don't think the liberals would be very pleased with me on my views on surrogacy. But of course, you see, there is, under our constitution, and I didn't get time to deal with this, but the right to reproductive autonomy is also a right under our constitution, under the right to life, Article 21. But when we talk of surrogacy, we are talking of two things. One, we are talking of the woman who actually physically bears the child, the surrogate mother. And we are also talking of the mother who will raise the child. So as far as the woman who bears the child is concerned, I think there's some very serious ethical issues also which have to be addressed. Because can a womb be for hire? Can you rent out? Is it ethical to rent a womb? Now, it's one thing if you have done it for, a relation or a friend on a one-off basis, somebody who could not bear a biological child. That is one thing. But what we find is that there is virtually an industry which flourishes. And you may say, yes, a woman who is very poor is able to bring, to bring some income into the family. But then she also she's being abused and exploited as the golden goose that's laying eggs, because she earns, several lakhs in one shot for carrying a child for 9 months. And the other thing is that, her body is constantly being, every few years or every couple of years, perhaps, there are women who are bearing children like that. So therefore, it's like a trade in an organ, and that has certain repercussions. We all know as mothers and as women that it's very difficult to bear a child. It has certain physical, psychological, psychosomatic impact on a woman's body and mind. So should one be doing that as a business? So there are very serious ethical concerns, and in my view, it should be regulated. And of course, as far as the mother who is, to raise the child, of course, look, if she has no other means, if she is unable to bear a child, there is somewhere she must get the opportunity of being able to. Of course, it also sounds very cruel, but, in a country where we have so many abandoned children, should we not be also encouraging adoption in a big way? That's also one issue. The irony that we have the maximum number of abandoned children, and on the other hand, we are also the surrogacy capital of the world. It's somehow, there's a very, very cruel contradiction over there. I think there's one more there, and we'll take that.
Does law allow surrogacy?
Yes, the law allows surrogacy. There is a bill which is also in the pipeline. For a long time, there was absolutely no regulation, and this whole thing, flourished in a big way. And you see, it was being misused at a certain level by, a lot of foreigners who would come into India. And in one case, I think it was a Japanese gay couple who came to India, and then they didn't want the child afterwards. So then what are you supposed to do with you're bringing a life into the world, and nobody is willing to take responsibility for it. So it's one thing if, there's a mother, an unwed mother gives birth and she abandons a child because of certain circumstances. But here you are, artificially, by artificial means, you're bringing a child into the world, and then that there is no security for that child. So, I'm amazed that there was absolutely no regulation or no even debate on regulation for such a long time. Yes.
Yes, ma'am. Is there any law in Constitution for marital rapes?
Oh, that's actually in current time that is being debated. No, marital rape is not outlawed under the penal code so far, but that matter is pending in the High Court currently. It's a very serious and a very important debate, and if you're asking my own views, I think it's something to be talked about, it's something to be discussed. But I think, one is, of course, the practical problem of how will you establish marital rape, because it's your word against your husband's word. But, be that as it may, I think there's a larger issue there. Whether rape, rape apart from the definition under the Indian Penal Code, which is, penetration without consent, I think there is a much larger, shall I say, connotation to the expression rape. It's a violation by somebody who you are not in any relationship, in any physical relationship with. So, there are a lot of people who feel that marital rape should be immediately outlawed, and it should be treated just as rape is under any other circumstances. But I would put in a more nuanced argument. It is something that we must campaign against. I think sexual relations, even with one's partner without consent, is something that is not acceptable. But at the same time, we must understand that, in a marital relationship, or in a live-in relationship, or any other where, the parties are in a physical relationship, there is an underlying presumption that, physical relationship is permissible. However, it has to be at the time and, place of choosing of both the partners. But there is a difference, and I think it will be debated in court. Let's see what happens there. There are many countries that have outlawed marital rape. Yes, there was a question here. I'm sorry, one more question. Let's just take this question here. यहाँ पर दे दीजिए, please. Just let the gentleman. He's been waiting a while, madam. Sorry, after that we'll come back to you. Sorry.
speech has impressed me a lot, ma'am. You started with the word gender, talking about women. I agree with you. From immemorial times, women were suppressed in our country. And do you agree with this, ma'am, that in the light of law, every gender is the same?
Yes, of course.
And
well, it's not the same,
yes.
but it should, everybody is entitled to the same fundamental rights.
And recently, it's issued, I think, the Supreme Court dismissed a bill which makes rape, sexual harassment, stalking, outraging modesty gender neutral. And also, I wanted to tell that men were always looked upon as perpetrators of sexual crimes, but not women. And also, men have been the victims of domestic violence and also dowry-related murders. And you know the misuse of Section 498A. I did not tell about that. Men have been the targeted section in this society. And the judiciary has been female biased, if we have to say that. In most of the laws, there were no laws to protect men from a minuscule section of women who try to misuse them. And also, as you have spoken about gender laws, and where is the justice for LGBTQ community, which they have been waiting for justice? Thank you, ma'am.
Thank you. I think it's very wise of you to have come and brave of you to have come to a women's summit and champion the cause of men. But yes, I agree with you on some count that, look, laws are often misused and abused. And I think I did mention that in the context of sexual harassment in particular. Some of these laws, particularly in the Indian Penal Code, dates back to 1860. And we do know that although, women have made, at least certain sections of women have made great strides in recent times, but the overall, if you were to look at the net situation, I think we are still, women are far, far, far behind. Laws are ultimately an expression of what is currently happening in society, what needs to be addressed in society. So I think what the court seemed to have said is, in that case which you mentioned, the PIL, is that, look, these laws were meant to be gender specific because they were addressing a certain, a malaise that had afflicted society. And therefore, naturally, dowry, I mean, it's horrible. It's still prevalent despite the fact that we've had all these laws. It's still prevalent, right? So dowry hasn't gone away. Therefore, it cannot be said that we should do away with dowry laws. But yes, we must do everything we can to prevent abuse of those laws and misuse of those laws. And I think recently there has been a judgment of the Supreme Court on that subject. So I think they have watered it down to some extent. So that's coming. Now, at a time when, if there are crimes against women, against men, if it reaches those proportions, I'm sure our legislature will respond and react at that stage. Because ultimately, in Parliament, it's mainly men. So they will, I'm sure they will address your concerns if they are required to be addressed. And as far as the LGBT community is concerned, yes, I think every citizen of this country is entitled to equal rights. There's no question. There's a landmark judgment on transgenders, which was a very progressive judgment. 377, I think it's on its way out. That's what it seems to me. So there you are. I mean, bit by bit, society, ultimately laws are a reflection of what's happening in society. Thank you.
What's your take on women reservation bill and electoral polls?
Yes, well, I'm personally not such a votary of reservation in principle, because this debate has taken place, whether we should have a reservation or more representation of women in the judiciary. But I would never say by reservation. I would say take us on merit, or don't take us at all. And I mean, I'll give you the example of the judiciary, for example, that you'll see that in the lower judiciary, where the selection process is entirely merit based because you have to take an exam, etc., to get into the lower judiciary. You'll see a lot of women there, okay? But as you go higher and the method of appointments becomes more and more opaque and not based on objective criteria, you'll see the number of women going down. And in the Supreme Court of India, for example, with sanctioned strength today of 31, when we have 25 sitting judges, you have one woman. And that is an abysmal ratio by any standards. And I remember that a couple of years ago, the Kenyan Chief Justice had visited India, and we were at a reception, and the first question that he asked me was, how is it that you have only one woman in the Supreme Court? And I felt quite ashamed. And what was very interesting is that in Kenya, not only are the numbers of women judges, and in many African countries, very high, but more than that, in Kenya at that time, the Deputy Chief Justice of the country was a woman, and she was a woman of Indian origin. So it says something about the diversity which they look for in judicial appointments. So in our country too, when they look, for example, the Supreme Court, you will find judges from all over the country. You will find that it's very interesting when you hear the accents, you see how they look. They all look very different, and it makes you very proud to be an Indian because, you have people from so many different parts. But then, and religious backgrounds also, very different communities they represent. Triple Talaq judgment was passed by 5 judges, only 1 was Hindu. So, it's interesting. That's the kind of diversity they have, but why is gender diversity not there? So, these are important. At the same time, when they brought in, and I'll say this at a public platform, they brought in one woman judge a few years ago who retired a couple of years ago, but she would sit late every day by an hour to an hour and a half. And what does that say about women? So therefore, we don't want tokenism. I think women can come on their own stream and they should come. And you find politicians on, so many different parts of the country, they're doing so well. So I don't see any issue. All right, I think we are, okay, one more. I can't hear, your mic is not on.
You are mentioning equal pay for men and women. Not only in India, recently I was reading a book, Lean In by Google CEO.
Yes, Sheryl Sandberg.
She has clearly written, men is paid according to their potential, women is paid according to their past accomplishments. What is your take on that, madam? Even here, if a male colleague of us who are far behind us also will be paid in hike or everything more than a woman who is hardworking. That is there everywhere, especially maybe government, there is at least a regulation, promotion and all. But private sector is not like that. And not only in India, this is a global problem. And she has clearly mentioned in that book.
Yes, you're right. It's a global problem. But I would say that, society will move bit by bit. As I said, our grandmothers didn't need to go into the workplace. They never thought of going into the workplace. So, attitudes will also gradually change slowly when men begin to recognize that, this is the way society is going to be. So I think it's very difficult to change a status quo, a sort of patriarchal mindset. I mean, and we mentioned the Triple Talaq case, but I really thought it would be pretty much a cakewalk, a practice like Triple Talaq to have it struck down. And yet, look what happened. It was a 3-2 majority. There was so much reluctance. We succeeded, but it was still a 3-2 majority. Now, so, to change a status quo takes a very, very long time. So I think you have to keep chipping. I mean, and at some stage, you will find that it changes. Right, so thank you very much.
Thank you, Ms. Madhvi Diwan, for the valuable information. Now I call upon to the stage Mr. Ayush Nadanpalli ji to felicitate Madhvi ma'am. Mr. Ayush Nadanpalli is the CEO of an IT company with voluntary responsibility and General Secretary of Samachar Bharati and Prant Prachar Pramukh, Telangana of RSS. I invite you, sir.